Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode number 238 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where, together with my colleagues, we provide advice and assistance to both employers and employees on all aspects of employment law. I would like to start this episode by wishing you a very happy new year. I'm recording this at the beginning of January 2025, and you will be receiving it the first week of January 25. So I hope that it started off well for you and your first day back at work is good. And as it is the first episode of the year, I'm going to be doing a bit of a rundown on the changes that took place in 2024 and looking ahead to 2025. So without further ado, I'm going to get into this week's featured content. So as I said, it is the start of the new year, and I thought it would be a good opportunity to look back and reflect on some of the key changes that took place in 2024 to ensure that you are aware of what's happened and that you are taking steps or have already taken steps to comply with the changes in the law. So I'm going to give you a rundown of the key changes and then a little look into what's to come for 2025. Many of the things I'm going to be talking about today I've covered off in previous episodes of the podcast, or you can find the resources on our website, which is realemploymentlawsadvice.co.uk. So I'm going to give you just a quick rundown of those changes. Now, the first one was a very welcome change for all, which was a change to the holiday entitlement calculations and the calculation and way that you pay holiday for those staff who have irregular hours or who are part-year workers. So many of you will recall that there was a case in 2023 which caused significant confusion for everybody about how you calculate pay in relation to part-year workers, and it impacted on those for 0 hours. Because of that, the government changed the law and set out very clearly within the working time regulations the details about pay and how you deal with holiday pay and entitlement for those people who work part year. So it means that there's a simpler way of calculating their holiday entitlement for those people who don't work on regular shift patterns, for example, or regular hours. Now, you can find all the details about this on the website, as I say, or I did do an episode on it, episode 222 of the podcast, which covers this off. But if you haven't already noted those changes or made changes to the way that you deal with things, then it's important that you have a look at that to ensure that you are complying with the current law and also that it's working best for you and for your employees. So a significant change there, making everybody's life a bit easier with clear guidance on how to calculate holiday entitlement and holiday pay for those people who work irregular hours or part of the year. The next change that came into effect in April of 24 was an expansion of the flexible working rights. Again, many of you who listen regularly will recall we talked about the government's plan, or the Conservative government at the time's plan, to change flexible working and to make it more accessible, and there had been significant consultation and work on it. Then when the changes came in and were actually brought into effect, they weren't really significant in relation to flexible working, but are some key things that employers need to know. So the main points that you should have noted in relation to flexible working requests is that from April 24, employees have the immediate eligibility to make a flexible working request, so they can make it from the first day of employment rather than waiting for 26 weeks as they had done before. Another significant change is that employees are permitted by law now to make 2 flexible working requests within a 12-month period, and you only have 2 months in which to respond to those flexible working requests rather than the previous 3 months. There is also an obligation on you to consult with employees before you refuse a request, so you actually have to engage in some meaningful conversation about their request before you can refuse it. but you don't actually have to explain the significant reasons why. You have to give one of the 8 reasons why if you're refusing a request, but you don't have to go into a lot of detail. Although my advice, as I've said before, is to try to provide as much information as you can in order to ensure good employment relationships going forward. And finally, employees no longer have to explain in their requests what the potential impact could be of their request. There were a few tweaks to flexible working rules and how you deal with requests, including the extension of the right to make a request from employees from day one and the ability, as I say, to make more than one request in a year. The next change that came in April 24 was the introduction of carers leave. I have talked about carers leave in the past and have been quite vocal in my feelings about carers leave, and I actually think it's a bit of a waste of time. But nevertheless, it does provide employees with the entitlement to have 1 week of unpaid leave per year to care for dependents who have long-term care needs. The leave can be taken flexibly, so in individual days or as a single block, and is available from the first day of employment. And the carers leave rights apply to anyone who the employee has a caregiving relationship with. So it doesn't have to be necessarily the immediate family members as long as they have that responsibility for care. So it's important to note that that is a legal right now. I know that many employers do offer carers leave to employees as part of their benefits package or just as part of being a good employer. But if you don't have anything in place, it's important that you take note of the law requiring you to provide carers leave if requested by an employee. Next up is changes to paternity leave. Again, a few small minor tweaks to paternity leave rights. So it basically changed the ways in which employees can request paternity leave and enables employees to take their 2 weeks paternity leave as 2 single weeks rather than previously having to take it as 1. And employees can now take their paternity leave at any time in the first year of the child's birth. Again, some minor changes in relation to the kind of flexible working part of that and in relation to paternity leave and family leave rights, but not any huge changes. The next significant change in April 2024 was an extension of the redundancy protection period for pregnant employees and those who are taking a period of family leave. You may be aware that employees have the right to be offered alternative employment ahead of any other colleagues in a redundancy situation where they are on a period of family leave. The law changed in April so as to extend that period for up to 18 months after the birth of a child or placement of a child for adoption or the taking of shared parental leave. So now, pregnant employees and employees who have returned from a period of family leave have that right to additional protection in a redundancy situation. The reason for the change is as a result of the acknowledgement that employees typically who are pregnant or take maternity leave are more vulnerable in relation to redundancy situations. And the extension of the law provides that additional period of time following return to work when employers have to consider those employees for suitable alternative ahead of colleagues. It doesn't mean that you can't make an employee redundant if they are pregnant or on a period of family leave, but it just means that in a situation where there is a suitable alternative, that has to be given by priority to those employees ahead of colleagues who are currently at work. In episode 235 of the podcast, I did cover off a redundancy protection case, which was in relation to the law before the change to the extension of the period of time, but it still gives more details in there about how this works in practice should you need, and it's quite an interesting case to have a listen to. Moving on to later in the year, in October of 2024, the sexual harassment prevention duty was introduced into law for all employers. And what this means is that all employers, regardless of size, now have a legal obligation to take reasonable steps to prevent sexual harassment from taking place in the workplace. I have covered this off extensively in the podcast in the past, and you can have a listen to episodes 218 or 233 for more information about how that duty works in practice. But in essence, our advice is, in order to ensure that you are complying with that obligation, you should, as a very minimum, be undertaking a risk assessment within your organisation. You should be creating a policy and raising awareness in relation to sexual harassment, and providing all managers and employees with training so that they understand what sexual harassment is and what you need to do in order to prevent sexual harassment from taking place in the workplace. Now, if you haven't already taken steps to ensure you comply with the new law, it's important that you do so, because if an employee brings a claim for sexual harassment against you, you won't be able to backtrack on this. You won't be able to go back and say, oh, well, we have now done it. It won't make any difference. You need to do it before any issues arise in order to have that protection. It will impact on any